Ms. James.
Thank you, Mr. Chairman. I also would like to thank Madam Chairwoman Bass and members of the subcommittee. Thank you for this opportunity. I also would like to, for the National Council, on behalf of the National Council, express our sympathy on the loss of Congressman Cummings. He was a huge champion for us and always had an open door policy for our concerns. And so we will truly miss him. Thank you again for this opportunity. Again, my name is Andrea James. I'm the Executive Director of the National Council for Incarcerated and Formerly Incarcerated Women and Girls. National Council is a membership-based organization working to end the incarceration of women and girls. It's an honor for me to share our views on implementation of the First Step Act and next steps Congress should take to transform the criminal legal system. Regarding the First Step Act implementation, reforming the criminal legal system is one of the most important issues of our time. This country incarcerates more people than any other developed nation in the world, with over 2 million people incarcerated, an increasing number of whom are women and girls. At the federal level, we incarcerate approximately 177,000 people, 45% of whom are incarcerated for a federal drug offense, and a disproportionate number of whom are Black and brown. This is a national crisis that Congress must address. When the passage of the First Step Act, Congress attempted to build on several important reforms that preceded it, the Second Chance Act of 2008 and the Fair Sentencing Act of 2010, to continue to move the ball forward. And while there have been some modest but important improvements to the system as a result of the passage of the First Step Act, giving judges greater discretion to depart from mandatory minimum sentences, making the Fair Sentencing Act retroactive, reducing some mandatory minimum sentences for drug offenses, ending juvenile solitary confinement, expanding compassionate release, and increasing good time credit to reduce sentence lengths for individuals currently incarcerated, there remain key issues with respect to its implementation and more work that needs to be done to transform the system. As a membership organization with members inside and outside of prisons, we receive dozens of emails a week from women who are confused about the First Step Act, having received conflicting information, making it difficult for many incarcerated people to take advantage of what the First Step Act has to offer. Much of the confusion has been the result of the exclusions that were included within the bill and completely bar far too many people from the Act's benefits. Literally, 68 categories of people may not receive earned time credits, despite their successful participation in educational programming, essentially closing the door on individuals who most need help in preparation for a successful return to our communities. Also excluded are people who are slated to be deported after their sentence is completed, denying them any chance to prepare in any way for that transition. As we look towards the future, Congress must work to avoid unnecessary exclusions that ultimately undermine efforts to rehabilitate people. Regarding the risk assessment tool, we are concerned that the tool will incorrectly identify women as likely to recidivate based on static measures, such as the crime for which they were convicted. We therefore urge that the approach to developing the risk assessment tool be modified. The circle of people involved in developing the tool must be widened to include the expertise of qualified, formerly incarcerated people. The Hudson Institute is hosting the development team and has selected academics who may have strong technical credentials, but none of whom have direct experience with the criminal legal system. Experiences of currently incarcerated people must also shape the development of the risk assessment tool. By definition, women serving decades-long sentences will be flagged as high risk. In fact, they are the opposite. Women who are serving long sentences are integral to the day-to-day functioning of the prisons. They teach other incarcerated women and prison staff the procedures of the prison, including training for industry jobs, such as Unicor. Long-timer women counsel new women adjusting to life in prison, provide comfort and advice to those separated from their children, and mediate interpersonal conflicts. These contributions should be captured in the risk assessment tool. women like those who have traveled here with me today, Virginia Douglas, Justine Moore, Tahiba Bain, all having served decades in a federal prison and now leading the movement to end incarceration of women and girls, could contribute significantly to the risk assessment discussion and development in addition to the statisticians. Finally, credit for earned time must be assessed retroactively, taking into consideration the ways many incarcerated people already have made great strides in their personal transformation against great odds during years of incarceration. Ultimately, we recommend that Congress ensures the Department of Justice addresses all of these issues before anyone is assessed by the pattern tool. Regarding next steps, directly impacted people must have a seat at the table. As experts in the field, our goal is to encourage meaningful reform, and we are entitled to ongoing, meaningful opportunity to explain why we don't believe something goes far enough and what else is possible, such as our fight for inclusion of retroactivity. I was incarcerated at the federal prison for women in Danbury, Connecticut during the passage of the Fair Sentencing Act and the fix of the sentencing disparity between crack and powder cocaine. I will wrap up with it was painful to see how many deserving women could not benefit from its passage because two sentencing provisions were not applied retroactively, and it's why we fought to include retroactivity not only for FSA, but also for changes to 3 strikes, 2 strikes, and 924C offenses in the First Step Act.
Thank you. We'll now proceed with questioning under the 5-minute rule. I'll recognize myself for the first questioning. Mr. Patton, I understand you had some problems with the answers that I got in the questions I asked the director about the crisis at the MDC in Brooklyn and the response to it. Could you elaborate?
I will. And I don't mean to blame Director Sawyer. I know she's only been in the position for 2 months, so she wasn't around when the crisis happened.
It's all her fault.
But I think she's been misinformed about some of the things you asked her about. First of all, I just had a meeting with the Associate Warden of the MDC 2 days ago because I'm trying to follow up with them on a number of these things. And I asked the very same question you did about long sleeve and thermal attire because they're not there yet on fixing the HVAC system, as Director Sawyer acknowledged, and we're coming up on winter. And the answer I got was, no, we're not going to do that. People
are not going to get thermal.
That will not become part of the standard issue. We will buy extra sets in case we have an emergency. But that is not what the recommendation is because there is an ongoing problem. It needs to be part of the standard issue. Now that sounds like a small thing until you sit in a 60-degree cell in paper-thin short-sleeve scrubs. It's a real issue, and that was just wrong, at least as compared to what the MDC is telling us. She said that the people with the CPAP machines were offered to move. Now, I know, Chairman, you were present on one of these tours. I was personally there. I mean, that's news to me, is all I'll say about that. Those people were terrified. They were terrified that their life was in danger. They were suffering. They were not given an option to move somewhere else. And so it's important to correct the record on that because if there's not an acknowledgement that the problem existed, I'm worried about a solution being put in place to solve it moving forward. Lastly, she said that there was a communication problem that the MDC officials forgot to communicate on some of these things. There was no forgetting to communicate. We were peppering them with questions, and we were getting demonstrably false answers back about what was going on there. That was not negligence. It was not a slip of the mind among the BOP officials there. It was intentionally misleading us about what was happening in the institution.
To your knowledge, has anyone been disciplined or admonished for intentionally misleading?
Quite the opposite. My understanding is that the warden at the time, Warden Quay, not long after this incident was promoted, and he now oversees multiple institutions. That's my That's my understanding from press accounts.
Well, it's my understanding too, and I must say that he was, when I was there, completely unresponsive. Let me ask this: Section 404 is a section of the First Step Act that made the Fair Sentencing Act of 2010 which address the crack powder cocaine sentencing disparity retroactive. Although the text of the First Step Act presents a straightforward application, the Department of Justice, we understand, regularly takes the position that retroactivity is not appropriate. In your experience and for federal defendants across the country, how is the retroactive application of the crack penalty reforms of Section 404 being applied? Are they being applied?
You know, at the end of the day, the vast majority of judges are doing the right thing, I think. But it's not because the Department of Justice is making it easy. In fact, they're taking very strained and aggressive litigation positions that have been highly criticized by judges. So for instance, one example on the retroactive application of the Fair Sentencing Act, the crack quantities, they're saying our clients are not eligible for relief because we could have charged a higher quantity back when. And so the judge should take into account what we could have proven or what we could have done.
In the absence of a new trial, how can they do that?
Exactly. It's unconstitutional. It's not fair. And perhaps most significantly, it's just contrary to the language of the law and the statute and what Congress intended. There are two separate aspects to the retroactive application of the Fair Sentencing Act. There's eligibility, and then there's the discretion of the judge about whether or not to reduce the sentence. The law doesn't require judges to reduce a sentence. And for the Department of Justice to say people are...
The law does not require.
The law does not require a reduced sentence. It imposes upon the judge a duty to decide whether somebody is eligible. And then if they are eligible, the judge takes into account all of the usual sentencing factors and decides whether or not to reduce the sentence. And for the Department of Justice to make really strained arguments on the eligibility side is disappointing. And it means that even though thousands of judges are going, or not thousands of judges, but in thousands of cases are going our way on these arguments, a handful are not, and they're being selective about how they then appeal those, because they can be selective about what they appeal and what they don't. So they're being very aggressive about trying to create bad law from our perspective.
So the Justice Department is trying to sabotage the retroactivity feature of Section 404.
They're doing their best, in my opinion.
Thank you. I have one further question. You mentioned racial and ethnic disparities and disparate treatment in your testimony. How is pattern risk assessment tool still unfair with regard to race and ethnicity? And can you give us some examples, specific examples? I'm sorry, that's for Ms. Hamilton.
Yeah.
Dr. Hamilton.
I'm glad it's for Ms. Hamilton.
Dr. Hamilton, yes.
Yes, so I think I have some slides that can go up. First, let us do, for example, slide 4B. So hard to see, but what slide 4B is doing is giving you an indication for males. These are the percentages based on race of those individuals who fall in the minimum and low category and therefore gain the best benefits of pattern. And so you can see significant differences based on race of this eligibility in order to earn early release and to be incentivized to go through a lot of programs. And then my next one, if we can go to 2B, please. So this one is the idea also, this is for females, 2B. Sorry, I know we're skipping around. Well, the next one will be about, I had talked about differences in calibration. I wanted to show you what it meant. For females, so for females, this is going to be on the violent recidivism rate. And what you'll notice on the bottom then is on the left-hand side is those who are assessed females at minimum risk versus low, medium, and then on the right-hand side is high. And what you're seeing there in the bars are the recidivism rates of individuals who were categorized within those four risk categories. And notice then in each of those that, and I'm sorry that it's very small, but what you're seeing is racial disparity. So in any of the four groups where you're seeing differences in height, that's by race, meaning that, for example, a medium risk outcome doesn't mean the same based on risk. Or high, it just doesn't mean high risk means something different based on racial groups for females, at least in violent recidivism. But I do want to say I'm very happy to hear from Mr. Walters that they are correcting for, I would assume, something like this.
Thank you very much. My time has expired. Gentlelady from Arizona.
Thank you, Mr. Chairman, and thank you, all of you, for being here, first of all. My first question is for Ms. James, and I applaud your effort to reduce incarceration of women and children, but a couple times during your testimony, you said your goal was to end totally incarceration for women and children, and I think in your written testimony, you said you're committed to abolishing incarceration for women and girls. How are you going to do that? Aren't there some women that deserve to be in prison?
Well, I think that it's a bold mission that we have taken on, but we also have been incarcerated women. We have all lived in prisons. We know for sure, after that experience, that that environment, as prisons currently exist in this country, will never help a woman to truly heal and advance her life. And so we know, because we have been for some years now working on looking at what else is possible for women, what else is possible for girls, mostly things that are created within the communities that the women and girls come from, that could immediately significantly reduce the incarceration numbers of women and girls, and then help us to advance ideas about women who may be causing harm to other people, that will need some other source of resource other than just community-led programming. But certainly, a prison is not the place that will help us to do that.
Thank you. I was just curious because I was like, there's some people, I think, that can be released and into society, and it's good, but other people I'm not so sure about. That there's some people that need to be in prison is what I'm saying.
May I just mention something?
Ma'am, if you
Sure.
don't mind, I have other questions, and I only have 5 minutes, so thank you. Mr. Walters, I guess there's been a few criticisms and concerns about the review committee and the tool and the assessment and that type of thing. Would you like to address anything that's been said?
Well, I think there were some initial concerns about the committee and the background of the people, but I included the backgrounds in my written testimony. I won't take your time to read the backgrounds of the individuals, but they have a diverse group of points of view, but they're highly professional in what they've done, and the Justice Department has listened to us. We've sat with the Attorney General, the Deputy Attorney General, as well as Ms. Bacon and some BOP officials, and we've gone through a lot of these items, I think, in a way that is intended by the law. I mean, our job is to advise. And our job is to advise as under the law the Attorney General, and we've tried to address some of these issues about the structure of the instrument, but also the task that's involved here, the compression of time for implementation, the need to look at these programs. And as I mentioned earlier, one factor here that has to be recognized is the Bureau of Prisons has not evaluated its programs. I mean, to bring some of these programs in, they're going to try to bring in programs that have links to programs that are evaluated or in areas that we think will make a difference, but they're going to have to go back and look at how to certify and make them effective. Otherwise, you're going to have people sitting in programs that really don't do a good job in helping them with the needs they have. The whole needs assessment system has limits, and we've suggested some ways of using some unconventional instruments to look at needs and to measure whether programs are meeting those needs using things like functional improvement in people's behavior, so we're not just waiting until we look at what happens after they've been released for 3 years, after they've already been in the system. So some of those things are more radical changes. They'll, as I said, cost more money to train and implement these things in the Bureau of Prisons. But if you want to meet the goals of the Act, which I think everybody here wants to do, if you want to meet the goals of the Act, our job is to kind of give our best opinions, and we have a range of them from different backgrounds on what that takes. I have nothing negative to say about the Justice Department's willingness to listen to us. They have a tough job in implementing it. If they implement it, we don't.
Thank you, Mr. Walters. I do have one more question. And this one is for Mr. Payton. Mr. Payton, I got some information that the federal prison industries has struggled over the past number of years, and it was kind of surprising to me that there was a reduction, well, let me read what it says. Since 2009, federal prison industry sales have dropped 47%, and we've experienced financial losses totaling $182 million. During this time, the FPI, or Federal Prison Industries, has closed or mothballed about 40 factories. This reflects a reduction of more than 2/3 in the percentage of eligible inmates working in the program from 25% in 2000 to less than 8% in 2016. And this was like really surprising to me. I'm from Arizona, and we have a fairly successful program, the Arizona Correctional Industries. And at least in Arizona, I think I've heard from industries, everybody I talked to said they're in great need of workers, right? And so in Arizona, we even have people working as mechanics on trucks, you know, big semi-trucks, and so it's a good workforce. They come, they learn a skill, and then they're able to use that skill when they're released. And so do you have any idea why this is happening? I think it's part of this program that we're supposed to be getting more people to work. I don't understand what's happening here.
I wish I had an answer for you. I think that's probably a good question for Director Sawyer. But I agree with you. You know, that is one of the programs that has really been proven to reduce recidivism. And there's just not enough of it. And there are other programs that similarly, whether it's drug treatment or mental health counseling, that we know would reduce recidivism, improve people's lives, and there's just not enough of it. And it's why I mentioned in my opening statement that I have real concerns that the programming is there to really make the First Step Act a success.
Well, thank you. Yeah, I agree with you. In Arizona, I was quite impressed with what they all do. I mean, you have a whole call center where people, there's this in the women's prison, where people don't realize when they're getting answers on something that it's from a woman prisoner inside the prison. And obviously, they're very dedicated and show up to work all the time. So. Anyway, thank you all for your testimony. I appreciate it.
Gentlelady yields back. That concludes our hearing today. I want to thank our witnesses. I want to thank our members for attending. I want to thank our witnesses. And with that, the hearing will stand adjourned.